Correll, does that sound accurate?
Yes, thank you, Your Honor. And just for the record, I haven't had a chance. I had visited with Ms. Harris for about an hour and a half on Friday. Again, spoke to her on the phone, and my colleague had a visit her in the jail yesterday, and then we spoke this morning. So we've gone over this plea a number of times with her.
Thank you. Ms. Harris, were you able to hear what the prosecutor and your lawyer just had to say regarding what they believe your intentions are here this morning?
Yes.
They indicated to the court they believe it's your desire to withdraw your previously entered plea of not guilty and enter a plea of guilty to this charge in the indictment. I'll go over that with you to make sure you understand that and answer any questions you may have. We would then continue the sentencing to a later day to get a pre-sentence report completed, come back on a future day where there apparently will be a joint recommendation presented to the court that you be placed on community control sanctions, which is a fancy word for probation. Is that your understanding of the discussions that took place between your lawyer and the prosecutor, most importantly what you want to do here today?
Yes.
Well, before I can accept your guilty plea, I need to make sure you understand everything that's going on here. I need to make sure you understand what it is you're charged with and pleading guilty to, all the rights you have that you give up by pleading guilty, as well as all the possible penalties you face. So for me to determine all those issues, I'm going to ask you a series of questions. If at any point when I'm asking you any questions, if you're unsure, unclear of anything I'm asking you, if you need anything repeated or clarified, if you want a moment to speak with your lawyer so you could ask her questions, or even if you want to ask me questions, make sure you let me know that, because I need to make sure you understand everything that's going on here, okay? Do you need a moment?
No, okay. I was just sort of reiterating what you said.
Okay. All right, let's get started then. How old are you, Ms. Harris?
24.
I'm sorry?
24.
Are you able to read and write the English language?
Yes.
Do you have any difficulty with that or difficulty understanding what you read in the English language?
No.
Are you a U.S. citizen?
Yes.
Now, before you came into court here this morning, have you any drugs or alcohol of any kind?
No.
What about within the last 48 hours?
No.
Not even prescribed medication, nothing?
I have a prescribed medication. It's
What is that?
Clonidine.
Say it again?
Clonidine.
Oh. How do you spell that? Is this...
C.
Oh, I
Yeah.
thought you said something different. Clonidine, okay. Anything else? When did you last take that?
At 9 p.m. yesterday.
Are you currently under the influence of that medication right now, which is making it difficult for you to understand or appreciate where you are, what's going on, or to communicate or anything like that?
No.
Okay. Now, you should have, or you did, receive a copy of the indictment in this case previously. Let me take a look here for a second. You should have got that. It appears probably around the beginning, middle of July of this past year. Do you remember getting that, the document that sets forth the charge you're accused of committing?
Yes.
Now, in that indictment, you are charged with one count, and what is alleged here, and what you'll be admitting to, is on or about December 16th, 2024 in Willoughby Hills, Lake County, Ohio, that you did operate a motor vehicle so as willfully to elude or flee a police officer after you received a visible or audible signal from the police officer to bring your motor vehicle to a stop. It's further alleged your operation of the motor vehicle caused a substantial risk of serious physical harm to persons or property. That conduct constitutes the offense of failure to comply with an order or signal of a police officer as a felony of the third degree. Do you understand what you're charged with and pleading guilty to here today?
Yes.
Any questions for me about that? So you understand the nature of the charge you're pleading guilty to?
Yes.
Well, then before I can accept your plea, I need to make sure you understand all the rights you're giving up by pleading guilty. First of all, I have a right to a trial. Now, a trial could be to me as a judge, where I listen to the evidence and I make that decision whether you're guilty or not guilty. But you also have a constitutional right to have a jury trial. And that would be in front of 12 citizens here from Lake County who would listen to all the evidence each side wanted to present. The jurors would consider and weigh all that evidence, and then those 12 jurors would make that ultimate decision. And that ultimate decision reached by the 12 jurors would have to be a unanimous decision. That means all 12 jurors would have to agree together, one way or the other, whether you're guilty or not guilty. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to have a trial in this case?
Yes.
Now, if we had a trial, you'd have the right to have an attorney represent you. If you cannot afford an attorney, the court would appoint one for you free of charge. Do you understand that?
Yes.
Now, at a trial, if we did have a trial, the prosecutor here would represent the state of Ohio, and she would have what we refer to as the burden of proof. With her having the burden of proof, what that actually means is that it is her job, or she bears the responsibility or the obligation to prove you guilty at a trial before you could ever be found guilty. You're presumed innocent of this charge. That presumption of innocence sticks with you and remains with you until the state, if at all, was ever able at a trial to overcome that presumption of innocence and prove you guilty. Do you understand that?
Yes.
Now, when I talk about this burden of proof, since this is a criminal case, that burden is what we refer to as proof beyond a reasonable doubt. That's the highest burden of proof there is in our justice system. What it means, it's the amount of the evidence and the quality of that evidence the state has to present at a trial to prove you guilty. So in this case, the state would have to present evidence to prove each element of the offense I just read to you beyond any reasonable doubt before you could ever be found guilty at a trial of this charge. Do you understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to make the state prove you guilty beyond a reasonable doubt?
Yes.
Now, in order to do that, or at least in order to try to do that if we had a trial, the prosecutor would bring witnesses into the courtroom to testify for the state by answering questions from the prosecutor. Once those witnesses answered the prosecutor's questions, then your lawyer would have the right on your behalf to ask those same person's questions, and we call that cross-examination. She can ask them anything she wanted to within certain rules. You understand that?
Yes.
Do you understand by pleading guilty you're giving up your right to cross-examine or confront these witnesses that would come in here and testify against you?
Yes.
Now, you'd also have the right at a trial. You could call your own witnesses to come to court to testify for you if you wanted to and answer your lawyer's questions. Now, you don't have to do that. You're not required to do that. But you have a right to do that if you wanted. Do you understand that?
Yes.
And you further could request this court issue an order, and we call that order a subpoena. What a subpoena would actually do is it would force or make someone come to court and testify for you by answering your lawyer's questions if they weren't willing to come in voluntarily or on their own. Do you understand that?
Yes.
You realize you're giving up that right. Now, you'd also have a right at a trial. You could choose to testify on your own behalf if you wanted to. But you do have a constitutional right not to testify if you don't want to. That's a decision. That is a choice that you would have to make. Do you understand that?
Yes.
And since that's solely your choice, what that means then is that nobody else could force you or make you, nobody could compel you to testify against yourself at a trial if you didn't want to. I can't make you testify. But most importantly, the prosecutor here, she would not be allowed to call you as a witness and make you get up on the stand and answer questions and testify. Your own lawyer can't make you testify if you didn't want to. Do you understand that?
Yes.
Do you further understand that if we did go to trial and you were found guilty of this charge, you would have the right to appeal or challenge that guilty finding to a higher court that sits above me and reviews my decisions? By pleading guilty here today, you're giving up or waiving any right you have to appeal a guilty finding that this court will enter if your plea is accepted, as well as any other issues that you could raise or brought to my attention up to this day. You understand that?
Yes.
All right, Ms. Harris, you understand all these rights we've just discussed? These are all the rights you have and all the rights you give up by pleading guilty. You understand them all?
Yes.
Any questions for me?
No.
You still want to plead guilty?
Yes.
You understand a guilty plea is a complete admission of guilt, so it means you're admitting to the facts being alleged by the prosecutor. We're not going to argue that you didn't do it, or that it's someone else's fault, or anything like that. Do you understand that?
Yes.
Further, as a result of pleading guilty, the effect of that plea is that you first will be found guilty by the court of the charge if I accept your plea, and then you will thereafter, on another day, be sentenced by the court. Do you understand that?
Yes.
Now, as far as sentencing goes, you're pleading guilty to a felony of the third degree. This offense is punishable by a possible term in prison of a minimum of 12 months, a maximum of 60 months, or increments in between of every 6 months. So 18, 24, 30, 36, 42, 48, 54, 60. So if I impose a prison sentence, and prison's not mandatory, but if I impose a prison sentence, I'd select one of those numbers, and that'd be the number of months in prison you have to serve. You understand that?
Yes.
Now, do you have any other charges pending against you right now anywhere else?
Yes.
Where's that?
In Cleveland Heights.
Okay, is that a felony or a misdemeanor?
Misdemeanor.
Okay, so I'm not concerned about misdemeanor. Any felonies anywhere?
No.
Okay. And the reason I ask that is if you're having another felony that you're sentenced to prison on before you get sentenced here, by law, the prison term imposed in this case would have to be consecutive to that sentence, which means you'd serve that first and then my sentence. But you can't do that with a misdemeanor. It's got to be a felony.
Okay.
You understand that? And it's got to be a felony already imposed. I can't impose a sentence consecutive to some future possible unknown sentence. It's got to be already there. So that doesn't sound like an issue here. Are you currently on probation or parole or any type of supervision to any of the courts or agencies?
No.
Okay. Now, if a prison sentence is imposed, I'm sorry,
I'm sorry.
do you have a question for me?
No.
Okay.
No, I just wanted to make sure I had a correct understanding of what was pending in Cleveland Heights.
Do you need a minute, or are you good?
No, we've clarified. Sorry for
No
interrupting.
worries. Now, if a prison sentence is imposed, you could be placed on post-release control, and under one circumstance it's mandatory, one circumstance it's optional. If the court determines that this offense is an offense of violence, and that is defined as an offense that is purposely or knowingly committed and involves a physical harm to a person or a risk of serious physical harm to persons, then post-release control is mandatory for at least 1 year, up to possibly 3 years. If it's not an offense of violence, then it's discretionary to parole for up to 2 years. And what post-release control is, it's sometimes referred to as parole, a period of supervision you would be on after you serve the prison sentence. And again, at a minimum, it's discretionary for up to 2 years, and it's not up to me, it's up to the parole authority to decide that. And it could be mandatory if it's determined, again, that the offense involved a physical harm to a person or a risk of physical harm to persons. Do you understand that?
Yes.
If you are on post-release control and you violate any of the conditions of your supervision, the parole authority could return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half of whatever the prison term is imposed by this court. Do you understand that?
Yes.
All right, now aside from the possible prison sentence I just mentioned, there are other sanctions that could be ordered. There's a possible fine in this case of up to $10,000. You could also be ordered to pay court costs. You could also be ordered to reimburse the county for any cost of confinement, community supervision, or treatment if any that were applicable. Do you understand that?
Yes.
Is restitution an issue in this case, Ms. Himmeline?
No, it is not, Your Honor.
There is a mandatory driver's license suspension that I'm required to impose in this case of at least 3 years, and I could suspend your license permanently for life. Do you understand that?
Yes.
Is there a prior conviction for this offense?
No.
Okay.
Judge, if I could have one moment.
Sure. I just told her about the suspension, right? Is that where I left off? Now, Ms. Harris, a few moments ago I explained the possible prison sentence, and when I did that I used the word possible. Prison's not mandatory with this charge. You are eligible for probation, or what we call, as I said before, community control sanctions. Do you understand that?
Yes.
Now, do you understand that just because you're eligible doesn't mean you automatically will be put on probation? It means it will be considered by the court if that's what you're requesting. It appears you are. So it will be considered by the court. I'll look at all the information provided, and I'll make the decision I think is the right thing to do. Do you understand that?
Yes.
Now, if you are put on community control sanctions, it could be for up to 5 years of supervision, and as the judge, I have the discretion to order a wide variety of rules or conditions for you to follow. One of the conditions of community control or probation can be in order that you serve a term in the Lake County Jail of up to 6 months as a condition of probation. Do you understand that? Now, if there's any incarceration imposed, whether it's local incarceration, as I just mentioned, or prison, you do get credit for the time that you've been in, so thus far. You understand that?
Yes.
Okay. If you are on community control sanctions and you ever violate any of the rules or the conditions that I impose, we would have a hearing to see if you're what's called a probation violator. If it was determined that you were, I could extend your probation up to 5 years if it wasn't initially 5 years. I could impose more restrictive sanctions against you, or I could terminate your probation and send you to prison at that point. And if I did it then, again, it could be for that period of time I mentioned before, between 12 and 60 months, or the 6 months increments in between. Understand that?
Yes.
Lastly, when we do proceed to the sentencing hearing, you'll have the right at that time not to say anything you want, anything you'd like me to know or consider. Your lawyer could speak on your behalf. She can recommend the sentence to the court. The prosecutor can also recommend the sentence to the court. Do you understand that?
Yes.
Do you understand that whatever the lawyers say at sentencing regarding what they think the sentence should be, it is just what I said. It's a recommendation. I'm not obligated to follow that if I didn't think that was the right thing to do. Do you understand that?
Yeah.
All right. Well, do you have any questions for me about the potential penalties you face by pleading guilty here?
No.
You understand all the possible consequences?
Yes.
Do you still want to plead guilty?
Yes.
Have you had enough time to discuss this case with your attorneys, have them review the reports with you, discuss issues, answer whatever questions you may have?
Yes.
Has your attorney, or has anyone for that matter, made any promises to you about what's going to happen at sentencing, which is inducing you to plead guilty?
No.
Have you been threatened or coerced in any way to plead guilty?
No.
Excuse me. Are you entering your guilty plea here today freely and voluntarily?
Yes.
All right, Ms. Harrison, any questions from me at this time regarding anything we've just talked about? What you're pleading guilty to, the rights you're giving up, the penalties you face? Any questions at all?
No.
Do you need any more time to speak with your lawyer before we go forward with your plea?
No.
All right, then what's going to happen at this point, the prosecutor here is going to explain for me what she believes the facts would show if we had a trial. I need you to listen to her, because then I got some questions for you, all right?
Okay.
Simline?
Thank you, Your Honor. Had this matter proceeded to trial, the state would establish beyond a reasonable doubt that on December 16, 2024, in the city of Willoughby Hills, Lake County, Ohio, the defendant, Kentronique Harris, operated a white 2025 Honda Civic with dark window tint on I-271 northbound. When Willoughby Hills police attempted to initiate a traffic stop on that vehicle, they activated their overhead lights and sirens. The defendant did not comply and instead fled from the officer in a manner to create a substantial risk of serious physical harm to persons or property. With regard to the pursuit, the dash camera does demonstrate that the pursuit occurred at approximately 2:35 p.m. The weather was overcast and the roads were wet. There was moderate traffic. The defendant did travel at a high rate of speed with lane violations and came close to other motorists on the highway. The pursuit lasted approximately 2 minutes. Thank you, Your Honor.
So, Ms. Harris, were you able to hear what the prosecutor just had to say regarding what she believes the evidence would show if we had a trial?
Yes.
And what, if anything, do you have to say about those facts as she presented them? Are they accurate? Did you do what she said?
Yes.
Very well, then, regarding count one, charging with failure to comply with an order or signal of a police officer, a felony of the 3rd degree, what is your plea to that count at this time? You could be seated. I appreciate that, but it's...
Guilty.
I'm sorry, say again?
Guilty.
All right, I have in my possession at this time a 4-page document called a written plea of guilty and judgment entry, which sets forth everything we just talked about. Before I can accept your guilty plea, I need to be assured you understand this document and what it says, and that you've signed it here in open court. Now, my understanding is that before I came out here, you had a chance to review this document with your lawyer. Is that correct?
Yes.
Ms. Corral, is that accurate? Did you read this over with Ms. Harris, review it with her, answer her questions?
Yes, and a colleague reviewed it with her in the jail last night, and we weren't aware of the court's policy to execute it here, so we executed one last night, and then again went over it and executed one today.
Okay. Based on your discussions with her, did she indicate an understanding of the contents of this document?
Yes, Your Honor. I believe she has knowing, voluntary, intelligent understanding of the document, of the rights she's waiving, and of the consequence of entering the plea.
Is that correct, Ms. Harris?
Yes.
Do you understand what this document says?
Yes.
Do you have any questions for me about it?
No.
Now, it does appear in the document I have here that you signed this document. Did you sign it here this morning?
Yes.
And you witnessed that, Ms. Crum?
Yes, Your Honor.
Ms. Himmeline, you as well?
Yes, I did, Your Honor.
Very well, then. At this time, the court will accept the defendant's oral and written plea of guilty. Let the record reflect the defendant was here in open court with her lawyer, advised of all her constitutional rights, and made a knowing, intelligent, and voluntary waiver of those rights. The court also finds the defendant understands the nature of the charge, the effect of the guilty plea, as well as the maximum penalty that can be imposed. Finding all this to be knowing, intelligent, and voluntary, the court will accept the defendant's plea. Find the defendant guilty of count one, failure to comply with an order or signal of a police officer, a felony of the 3rd degree, in violation of 2921.331B. This time the court will defer sentencing. I'll order a pre-sentence report and investigation. Any issues with drugs or alcohol that you want to explore with the drug and alcohol evaluation?
No.
No, Your Honor.
Okay, and then just the pre-sentence or investigation would be
Yes,
good.
thank you.
The judge reminded her, and everyone watching, that taking responsibility is the first step toward redemption. What do you think? Was the judge fair here? Let me know in the comments.